a 39-country high-risk list, indefinite processing holds, the threat of your already approved visa being pulled back into re-review. We covered these national security proclamations briefly before, but because the questions haven't stopped, we're taking the deep dive you need to move forward with total confidence. To cut through this, we're looking at the facts through the lens of our founding attorney, Chris M. Ingram. We are bringing his team's expertise to give you clarity on how these rules actually work. We've added the questions we're covering on the screen with timestamps so you can jump to exactly what you want to know. But we recommend you watch everything so you are fully aware of how these moving parts interact. What is the 39-country list? This is the foundation of the entire shift, a framework targeting individuals connected to specific nations USCIS now classifies as high risk. We are putting the full list of 39 countries on the screen right now. You can pause and check if your country of birth or nationality is included. It spans from Nigeria and Venezuela to Iran and Syria, and crucially, it also includes anyone using travel documents issued or endorsed by the Palestinian Authority. But knowing if you're on this list is just step one. The real question we need to answer is, what actually happens to your case once the system flags you? What is the processing hold for pending cases? Effective January 1st, 2026, we are seeing a shift in how USCIS handles cases for individuals connected to the high-risk framework. This connection is typically assessed by factors like your country of birth, nationality, or specific travel document status. In plain English, a processing hold means USCIS may move your case through every standard step: filing, biometrics, requests for evidence, and even interviews. But then, they pause. They hold the case at or near the final decision point for additional screening, which can lead to indefinite delays without an immediate approval or denial. For our EB1 or EB2 NIW clients, this hold typically hits when an I-140 or I-485 is otherwise decision ready. We want to offer a reassuring note. If you are not connected to this framework, for example, most of our Indian clients, your petitions and applications are generally expected to continue under normal processing patterns. Still, we always evaluate every full case profile before making a final call. But this screening doesn't just stop at new pending cases. It can actually reach back into approvals you already have. What is the re-review process for approved cases? Even if you already have your benefit, USCIS can now look back. Any approval granted on or after January 20th, 2021 can be pulled into a re-review if you're connected to that high-risk list. This could mean a notice for a new interview or a sudden request for evidence. While USCIS plans to issue operational guidance and a priority list for these reviews within 90 days by April 1st, there is no guarantee of a final resolution in that time frame. This leads us to the practical impact on the actual documents you need to live and work. How are immigrant visas and green cards affected? To understand this, we have to look at the typical two-step journey. First, the USCIS petition, like an I-140, and then the second step, which is either an I-485 adjustment of status if you're inside the US, or consular immigrant visa processing if you're abroad. For those connected to the high-risk framework, this USCIS hold is designed to hit that second step. It can delay final approvals of I-485 green card decisions, related employment authorization or travel documents, and other final step benefit approvals depending on your filing type. The bottom line is that for affected cases, timelines can stretch significantly, even when the case is otherwise approvable. But what about the visionaries who aren't looking for a green card yet? The ones relying on temporary work visas? Are non-immigrant visas and non-immigrant USCIS filings unaffected? In short, no. While the word visa often makes people think only about embassies and consulates abroad, many of the most critical work and status processes happen right here through USCIS. We are talking about petitions for H-1B, O-1, or L-1 status, applications to change or extend your stay, and even work authorizations in various categories. For individuals connected to the high-risk framework, it is simply not accurate to say these are safe from delays. USCIS may place these benefit requests into additional review. This internal USCIS wall is one thing, but there's a second wall being built outside of the US entirely. This is a separate policy from the USCIS framework we just discussed. Effective January 21st, 2026, the State Department paused immigrant visa issuance at U.S. embassies and consulates for nationals of 75 different countries. We are putting that full list on the screen now. It's much broader than the USCIS list, and you can pause to check it. In many cases, you can still apply and even attend your interview, but no immigrant visa will actually be issued during this pause. A key strategic difference here involves dual nationals. Your options may change depending on which passport you use to apply. We also need to be aware of layered delays. If your country is on both the USCIS list and this State Department list, you are facing hurdles at two different agencies simultaneously. So, with all these moving parts, when exactly does the clock start on all of this? What is the timeline and what should we expect? The clock is already ticking. The USCIS holds became effective on January 1st, 2026, and the duration is not fixed, meaning it can be extended or modified at any time. The State Department's 75-country pause on immigrant visa issuance follows on January 21st. Regarding re-reviews, this posture applies to any benefit approved on or after January 20th, 2021. While USCIS may prioritize some of these cases internally, official timelines are expected to vary widely across the board. What are the implications for your immigration journey? For individuals connected to the high-risk framework, the impact is tangible. We are looking at delays in final approvals for green cards, work authorizations in certain contexts, and other final step benefit decisions. You should also expect added screening, mandatory interviews, or new requests for evidence. However, for those not connected to this framework, including most of our Indian clients, processing is generally expected to continue normally. Even so, we verify this for every client based on their full fact profile, looking specifically at birthplace, citizenship, and travel documents. To see how these two distinct realities look in practice, let's look at some hypothetical case studies. Take Raj, an Indian software engineer. Since India isn't on the 39-country list, his EB-1 and green card application should move forward normally. Now contrast that with Amina, a scientist from Nigeria. Because Nigeria is on the list, her case is likely to be processed, but then paused at the finish line for that extra review. This highlights the need for a balance between security and fairness. Conclusion: how do we balance security and fair processing? While these proclamations aim to improve national security screening, the practical reality is that they often disrupt the lives of legitimate, highly skilled professionals and the U.S. employers who need their talent. It's also worth noting that concerns like public charge are already managed by the existing system. Specifically, through the I-864 Affidavit of Support, a legally enforceable commitment that can last up to 10 years. We know this is a massive amount of information to process. To provide some immediate clarity, we've pulled together the most frequent questions we're hearing from our clients right now to give you the bottom line. First, is India affected? No. India is not on the 39-country list, so most Indian cases are expected to proceed normally. However, we still review your full profile for additional factors, like your birth country, citizenship changes, or any unusual travel document history. What if my birth country is listed, but I'm a citizen elsewhere? It may still matter. USCIS can evaluate your connection to the framework based on multiple factors, not just your current passport. Can USCIS holds affect non-immigrant related filings like extensions or changes of status? Potentially, yes. If you are connected to the high-risk framework, these holds can apply because USCIS benefit adjudications include those non-immigrant petitions and related filings. How long could these holds last? There is no fixed end date. While some holds may resolve quickly, others can last many months or longer, depending on security screening results and future policy updates. And finally, what about already approved benefits? If your benefit was approved on or after January 20th, 2021, your case could still face additional scrutiny if you are connected to the framework. If you receive a notice from USCIS, our team responds strategically and promptly. In today's system, precision is the only way forward. Compare your history against these lists, and if you're concerned, reach out. Visit breakthroughusa.com to schedule your free consultation so we can evaluate your specific risk and build a game plan together.